Good afternoon, everyone. Thank you very much for joining us to today's Regulators Masterclass. My name is Yinka Edu, and I'm a partner at the Odo-Dom and Belo-Osagie Banking and Finance and Investigations, Compliance and Ethics team. We refer to that team as the ICE team for short. I'll be moderating this session along with my partner Adiola Smola, who is also part of the investigations team. For those of you that don't know the firm, Odo-Dom and Belo-Osagie is one of the largest commercial law firms in the country. It was established over 35 years ago. The firm advises on a wide range of legal issues and practice areas, including banking and finance, tax, litigation, mergers and acquisitions, telecoms, media, intellectual property, oil and gas, etc. We work regularly, as you can see from that broad range. We work with a very broad range of regulators also. I'm very glad that my personal key regulators are here, CBN, SEC, and the FCCPC. But we're well represented by a number of very important regulators as well. I mentioned those ones first in the hope that it will buy me some goodwill. We also have with us, or have registered to attend, NAFDAC, FIRS, NITDA, NCAA, NASD, NERC, NOTAP, NNPC, the CAC, ICPC, EFCC, FMDQ, NSCDC, and NSC. We're very happy to have everybody here. We're pleased with the level of interest. We have over 300 registered participants. Not all have joined us yet, but I'm sure that they'll join us as we go along. We're pleased that you're all able to attend. Our belief as a firm is that we cannot fully serve our clients by simply reviewing the law books. It's important for us to be able to engage with regulators, to understand their thinking, their priorities, and their concerns. For this, engagement between ourselves, our clients, and their regulators is essential. So today's event, as I said, today's event is an initiative of the ICE team. We have been having a series of webinars, which we've described as our September series, every Wednesday in the month of September. The last of these webinars will hold tomorrow. We have had webinars on crisis management, internal investigations covering corruption, employee misconduct. We've had a session on ethics, which covered issues like, well, personal ethics as well as board ethics. We've had a session on dawn raids, and finally tomorrow we have one on international data privacy rules, which is holding tomorrow. These sessions were open to the public generally and were targeted at corporates. They were very well attended. We've, however, decided that there are certain issues that are particularly relevant to regulators and SROs, and have therefore organized the sessions, this session this week and another one Tuesday next week, exclusively for regulators. Today we'll be looking at best practices for carrying out regulatory investigations, and next week we'll be discussing the best ways to drive compliance, and we look at what options are available in addition to the usual fines. We're very happy, as I said, to have almost 300 participants from over a dozen regulators. We're very fortunate, and today, in addition to the regulators, we're very fortunate to have two very knowledgeable speakers. We have Mr. Bamidele Soya. Mr. Soya, please wave. Mr. Soya comes to us with a great deal of experience on this topic. He's been working with the World Bank, means that his main constituency is government, and so he's particularly well suited to speaking to our regulators. Mr. Soya is Nigerian and UK qualified attorney. He's currently the chief counsel responsible for ethics at the IFC, International Finance Corporation, which is a member of the World Bank Group in Washington, DC. He joined the World Bank in 2010, serving as investigator, senior investigator, investigations manager, and most recently as EBC's chief counsel responsible for ethics in the African region in the World Bank. Bami has over 25 years experience in legal practice, investigations, and ethics. Prior to joining the World Bank Group, he worked as a managing associate in the London office of the international law firm of Linklaters. You may also have heard of Kroll. Kroll is a corporate investigations and risk consulting firm. They've been involved in various cross-border investigations and so are very well placed to discuss global best practices in investigations. Alexander Booth. Hi, Alex.
Hi, good afternoon, everybody. Hi, Yinka.
He's joining us from Kroll. He's an associate managing director at Kroll, the world's leading intelligence and investigations firm. Alexander is dual located in London and Nairobi, but I understand he's in Nairobi at the moment, and coordinates Kroll's work in Africa. His team advise government agencies, financial institutions, and large corporates on a wide range of commercial opportunities and sensitive challenges across the continent. These have included mergers and acquisitions, capital market transactions, regional entry strategies, reputational issues, dispute situations, asset recoveries, investigations in complex fraud and corruption. So we're very happy to have you both. Thank you very much for joining us. Before I hand over, so the plan for the afternoon is to have two presentations. The first one is by Mr. Soya and the second one by Mr. Booth. We will have, before I hand over to Mr. Soya, just to let you know, we'll have questions and answers right at the end. Please put your questions in the Q&A, in the sort of Q&A session. There's a Q&A button that you can see on your screen. This is for our audience. Please put your questions. Please put them in at any time. We may not take them until a little bit later, but put them in so you don't forget. And we hope that this will be a very useful session for everyone. Thank you again for joining. That's all, yeah.
Good afternoon. Thank you very much, Yinka. My colleague on the panel, Alexander, as well. Good afternoon in Nairobi. Some of you may have heard snippets of my conversation with Alex. I used to be in Nairobi, as Yinka alluded to, responsible for the work of the ethics office. In fact, I set up the ethics office of the World Bank Group in Nairobi. And now we're going to be opening an office in South Africa and also in Senegal, to cover the Africa region. But just to set the context, some of you may know the World Bank already. I currently work as the ethics officer for IFC, which is the private sector business of the World Bank Group. Let me also say that I hope you guys are keeping well. I would have loved to see you, to your faces. Unfortunately, we cannot do that, but I hope you're keeping well in our new normal, So setting the context, the World Bank is a state. It's actually a country. I put that, jokingly. It's a country in the sense that we have privileges and immunities. And so that informs some of the conversations we're going to have this morning. Because it has an international personality, we have privileges and immunities. And if I may also say that we have our own internal justice system. Some of you may not know that we have a court. We have a court that sits twice a year to hear appeals from investigation from staff. And we have a sanctions regime when it comes to the lenders, the clients that we lend to. If we discover corruption and we investigate and sanction them, they can also appeal within that framework of the World Bank Group. So I have a slide as a deck. I don't know whether we can put it on now. Thank you. So my talked this morning, or my discussion, because I see it more as a discussion, because I remember when I was told by Yinka and Adiola about coming on this, I said I'm a storyteller. I call myself a story whisperer. I've done several hundreds of investigations at the World Bank, covering all the way from Africa to Australia to China. And so, I share those experiences. So I see it more as a sharing of experiences and lessons learned. And even though this is going to be focused on workplace investigation, there's a lot of lessons there in terms of best practices for investigation. Okay, so let's move on to the first slide. What is a workplace investigation? I'm sure you guys already know what this is, but this is just to refresh our memory. It's not an investigation, whether workplace, internal or external. It's not to find somebody guilty. That's not the purpose. The purpose is to ascertain facts. and so that we can address where things went wrong. That's the whole idea. So we're not going there with a presumption of guilt. We're going there because we want to find out what is wrong. One of the very difficult areas that we investigate is fraud, as you know. So some other ones include harassment, sexual harassment in particular. And the job of an investigator is to collect the evidence and analyze that evidence and see where that evidence leads to. That is the role of the investigation. Let's move on to the next slide. Now, why is an investigation necessary? Some of you have heard in the news, I'm sure you guys saw what happened with the African Development Bank. This was an internal investigation of the current president, Mr. President Adesina, right? And it was in the news. And one of the lessons for me there is, as an ethics professional, that the ability of the institution to investigate somebody as important as Adesina, the president, speaks volume of their integrity program. It speaks volume of the culture of that institution. That is why an investigation is necessary. It's necessary to promote a culture of ethics, transparency, and compliance. We know that primarily we want to make sure that when policies or procedures are violated, we look at it. But most importantly, it speaks to the culture of ethics, transparency, and compliance. And as regulator, that is also very important. Another example that I want to share with you, and I'm sure some of you may know this, Adeola Yinka as well. If you remember in 2000, I think it was in 2005, Clippers, Los Angeles Clippers, right? When the chairman of the NBA, when he assumed office, does that ring a bell? David Silver, right? You remember that the owner, the billionaire owner of Clippers, Sterling, was heard to have made a recording, or his girlfriend made a recording of him making some racist comments, right? Now, the NBA chair had just been appointed. And guess what he did? He investigated the billionaire, constituted an investigation panel, investigated the billionaire, and gave him a fine of $2.5 million. The regulator issued a fine, the NBA regulator issued a fine of $2.5 million. It speaks to a lot of courage, especially when you are just starting your role as a regulator. And also, it didn't just end there. He banned Silverman, he banned him for life. In other words, he could not watch any NBA game, he could not attend, he could not even participate in any NBA activity. And eventually, Silverman had to sell Clippers. He was forced to sell. And, this is why, it's very important that it required courage. It required a lot of, a lot of courage, I would say, for him to have taken that decision. But he did it and sent a very, very powerful message. So this is why investigation is necessary. It serves as a warning and does prevent further violation. I put there the director and the STC. This was a case that happened at the World Bank as well, where a director had a relationship with a consultant. Now, I was talking about the rules, that we do have rules in regards to the code of ethics and regulations and staff rules that guides how we operate in the World Bank. And this particular director had a sexual relationship, a romantic relationship, which is not outlawed. You can have a romantic relationship, but it needs to be declared. If you are a supervisor, it needs to be declared to the Ethics and Compliance Office. He didn't do this. And during the investigation, he left, thinking that that would be the end of it. But we proceeded with that investigation, found that there had been a de facto conflict of interest, which it was, and barred him from rehire from the World Bank. In other words, he could not work at the World Bank anymore or any of our projects, and he could not access our premises. Now, come to think of it, he went to join a firm in London, and he came back to the World Bank for a meeting. And lo and behold, his colleagues were allowed to enter our premises, but the security at the gate would not allow the director. So I can just imagine the conversation at that moment with his colleagues. I thought you were working at the World Bank before, so how come you are not allowed to access this building? He was so pissed by that decision, he challenged the decision of the World Bank to bar him to this, we call it the World Bank Administrative Tribunal, which is made up of 7 independent judges. In fact, our own Teslim Elias, if you remember, was a judge of that tribunal, and his son, Femi, who's a good friend of mine, used to be the chief registrar of that court. Now, the tribunal, it was an interesting case. His lawyers argued, eminent lawyers, they argued that he resolved the conflict of interest within himself. And of course, the tribunal did not agree with them and said conflict of interest cannot be resolved by the party who's participating in that conflict. It had to be brought attention to the ethics and compliance function to be able to resolve it. And even as a senior member of staff, he has even a higher obligation, a heavier burden in terms of complying with the rules of the organization. And his application was thrown out. So that was an interesting case. It's necessary to democratize investigation. It is necessary to democratize investigation. So if we can move to the next slide. Thank you. Now, what do you require for a good investigation outcome? It has to start from even before the investigation. I think it is universally recognized that it's part of best practice to have a hotline, right? So have a hotline, various means for people to to raise concern. It's very, very important. I would recommend even having a third party provide the outline. A third party provide the outline. One of the other things I wanted to emphasize on is the last point on this page, which is the competence, neutrality, and independence in the selection of investigators. Now, these are steps, preliminary steps in investigation process. Now, and it brings me also to the additional case. It's very interesting because we were joking, we have a group of, we call it a Conference of International Investigators. So these are investigators who work in international development, the different organizations. And one of the things we were talking about was the mistake that was made in the additional case. That mistake was that they appointed an in-house investigator to investigate the conduct of the president of the organization. I don't know whether you get the point I'm trying to make. In any organization, the head of our organization is basically the head of everybody. So in order to investigate somebody like that, you needed to go outside to appoint an investigations team, right? So for independent, it's very, very important to be mindful. So the seniority comes into play in determining whether to choose an internal or external investigator, the complexity of the investigation. For example, we have had a situation in the past, if some of us can remember, when the World Bank president, this was maybe over 10, 12 years ago now, Wolfowitz, when he was involved in a scandal, and you remember that that scandal led him to be removed. But that investigation had to be punted over to an external firm in order to do this, because it goes to the integrity of the investigation itself, right? So when you consider the complexity of the issues we are talking about, the seniority of the person you are talking about, and those issues have to be factored into making that decision whether to use an internal or external investigator. There's so many professional firms, law firms, like Yinka and Adiola. These are people with a lot of experience who have done this over and over again. And speaking about additional, we were not surprised when they were complained by some of the stakeholders that this was not a fair, impartial investigation because it was being investigated by his own staff. And so, one needs to bear that in mind. Privacy and confidentiality as well. This also speaks to the need to have professional conduct investigation. I put there a case of a Latin windfall, which was a case of a consultant who had been investigated by the World Bank for corruption on one of our projects. And after the investigation, even though we didn't find that particular consultant guilty, we found some companies who had worked on the World Bank project. We found them to have colluded with some of our staff to defraud, to basically steal money on that project. Now, unfortunately, when the social media, we're in the era of social media and information spread, this consultant, they claimed that he was found guilty by the World Bank investigation, which was untrue. And I remember the consultant. This happened maybe in 2011, thereabout, when I joined, about I think a year of my joining. And he actually came to me. I spoke with this consultant, and I referred him to the team that was responsible for managing this case. And all he was asking for was information by the World Bank to address that he was not found guilty, that in fact we found him innocent of the allegations. Now, this dragged on for so long and nothing was done. At the end of the day, the consultant went to the tribunal, and the tribunal awarded him. He walked away with close to $1 million in compensation when you had his legal cost to it. Now, why am I bringing in this case here? Investigations has to be conducted on a confidential need-to-know basis. In other words, you've got to protect the privacy and the confidentiality of the subject as well. So there's a presumption of innocence, and that fits into that need to protect the subject's privacy and confidentiality. And in this case, the guy walked away with a lot of money. One of the things I mentioned here also is about the investigation protocol. It's very, very fundamental. It goes to what I would call substantive due process. It's substantive due process to ensure that you comply with your protocol for investigation. The G5 kidnapper case, this was also a very interesting case that happened at the World Bank, where a staff member had been alleged to have kidnapped to kidnap her domestic help. So we have a program at the World Bank where you can bring a domestic help from your country. And in this case, the FBI investigated, and they found out that it was not the case, that this lady did not kidnap the domestic help. The domestic help came from Uganda to Washington, D.C. of her own free will to work with the World Bank staff member. However, when the World Bank investigated this, they did not make that distinction, one. Secondly, they failed to follow the protocol by not giving her a due process. The procedural due process required that the staff member be given an opportunity to be heard. But because the rules of the bank had said, if you have a felony conviction, it is automatic termination. So even though this person was only found to have have lied to the FBI, not kidnapped somebody, but lied to the FBI in the process of the proceedings, it was still a felony conviction. But then the tribunal did find that they did not follow the process because they needed to have interviewed the person before preparing an investigation report. What they did was in contradiction to the investigation protocol. So that was the basis on which that decision was vacated, the decision to terminate the staff member's appointment. So this just speaks to a very important consideration as you think about a good investigation outcome. So if we can move to the next slide. How am I doing for time? I'm mindful that I only have about 40 minutes, right?
No, you're doing well. You're doing well. You are about halfway through.
Halfway through, okay. So timeliness. Each investigations need to be prompt. This is always, a question that is sometimes difficult to ask. Like somebody asks me, how long does an investigation take? And I'll say, look, it depends on the subject matter. If you are investigating fraud, for example, and Alex can speak to that, it can take years to investigate, especially because, with the World Bank, we don't have the kind of enforcement powers that a state actor might have, even though, we call ourselves an international person. And therefore, we sometimes have to rely on the cooperation of the subject and the witnesses. So depending on the subject matter, how complex is the investigation. If it's a staff matter which is contained within the organization, we normally complete our investigation between three to 6 months. But it's very important, and a lot of investigations have been vacated because of the time. I remember one of the cases that we had, which was a case of forgery of some of our documents, and it took about 9 months to do the preliminary investigation. Now, the preliminary investigation is to find out whether there's a sufficient basis to proceed to the formal investigation, and the tribunal did find that it was not prompt, that was too long, and therefore everything we had done was vacated, and the staff member was allowed to dodge the bullet in that case. So the other thing to be mindful of is also the planning and the organization, the scope. What are the rules or the law that has been broken? How you structure the interview, where you do the interview. Those are very, very important considerations to think about. In terms of attorney, client, and work product privileges, I hesitate when this is raised, because you as a regulator may need to show that you have done an investigation. So you cannot you cannot rely on it for one thing and then say you cannot use it for another. And also, strictly, an investigation is not legal advice, strictly speaking. And in a lot of cases where the courts have held that it's not legal advice, so to speak, the work product, and so they have limited privileges. And the last point I have here is about the outcomes, that investigations have to have an outcome. You have to hold one way or the other. And this is why it's important to have a professional do the investigation. I think in the next slide, we'll talk about making credibility assessment. This is part of what lawyers do every day. And it takes those experience to be able to do credibility assessment, to who to believe one way or the other. I did a slide here just on due process to emphasize the importance of due process in every investigation, not just workplace investigation, every investigation. There are certain minimum standards that are required, which have become legal standard in most jurisdictions. For example, there must be a reasonable and sufficient basis for initiating an investigation. In other words, you cannot initiate an investigation just because there's a rumor. You have to make sure that that rumor is steeped in fact to be able to launch an investigation. I've already mentioned earlier the procedural due process of presumption of innocence. You need to have a notice of allegation issued to the person. You give them an opportunity to respond and to put forward their defense. One area also is about legal representation. On our investigations involving third parties, we do permit legal representation in terms of somebody a lawyer coming in to listen, not to respond. When we interview the subject of the witnesses, they may afford themselves the services of a legal practitioner. However, in our entire investigation of our staff members, they may only come to the investigation with a staff relations counselor. In other words, we have advisors within the staff group. These are volunteers who may accompany the person who is being investigated or the witnesses to that conversation. So we'll move on to the next slide, please. So this is just a continuation of due process. This substantive due process, thorough and balanced investigation. You need to demonstrate that you followed up on exculpatory and vindicating evidence. Let me give you an example of this, where we had a case in Nepal. There was allegation against our staff member in terms of human trafficking, and also that they broke the law in Nepal by bringing foreigners to the country, saying that they are coming to work for the World Bank, whereas they were not. And there were a number of, how will I put it, something like, a taster, that this may not necessarily be the true story, right? Unfortunately, the investigation that was done did not follow up on those facts which indicated that there may be ill motivation. The witnesses were motivated to make up these stories. Now, in the investigation report and the attachment, it became very evident that the investigation did not do a thoroughly balanced investigation. And as a result of this, the decision to terminate the staff member was rescinded by the tribunal. The tribunal found out that the investigation was not diligent in following up exculpatory evidence. So it's very, very important to bear this in mind. We need to test the veracity of the evidence. I mentioned there about credibility. It's not a subjective opinion. Lawyers and magistrates and judges, they do this every day. So you have to choose between one evidence or the other. But in doing that, it's not subjective. It's a reasoned analysis of the evidence and looking at the demeanor of the witness, the past record, is there any motive to lie, the internal consistency of the evidence they are giving. Those are things that we consider in credibility assessment. Conduct of interviews. I've also seen in my time, I've also seen reports where you can see from the transcript that leading questions, suggestive questions are asked to elicit certain responses, and this will be picked on by a court or by a tribunal when they examine the report. We're going to move on to the next slide. Whistleblower protection policy. I think that's also important to bear in mind. It is best practice to have a policy in place. Now, what does this do? The whistleblower policy is intended to encourage staff members or third parties to bring concern so that the organization can deal with it. Currently at the World Bank, we have an extensive whistleblower policy. Our policy says that even if we don't do anything about it, so if a third party came to me and say that, look, your project in Kenya, you're giving money to build up the health capacity in Kenya, and the money is being squandered or stolen by the authorities in Kenya. If we don't do something about it, the policy allows the whistleblower after a reasonable time that he has not heard from the World Bank to contact our board. The whistleblower can raise those concerns to the board. It even says that the whistleblower can raise those concerns to external parties. So we have seen situations where we have read things in the paper. A whistleblower is entitled to go out. And I'll give you a case that best illustrates this. I call it the Argentine Dodger. I think I must have written it somewhere, the Argentine Dodger. That's what I call it. So this was a senior official in Argentina who was being investigated. There was this spate of cases that went to the High Court in Argentina, and one of the persons that were brought before the court was a board member at the World Bank, and the board member was invited to appear in court or summoned to appear in court. And he wanted to avoid that and claimed to the court that he was engaged on World Bank business, that he was traveling on World Bank business. Now, staff in the Argentine office, one of them pulled out his travel records. Travel records are public, so to speak. It's open to staff. It's open to our staff members. And you can look at my travel record or look at the president's travel record, and you can access it and you can pull it out. So one of the staff members pulled it out and sent it to the court to show that this person was lying, right? Now, when this case was investigated, somehow the staff members who did this, they were found to have committed misconduct by accessing official. So even though it's public to the staff, it's open to staff, it was deemed official documentation. And as a result, they were disciplined and they appealed to the tribunal and argued correctly that they were whistleblowers. You know, they were subject to the protection against retaliation. And what the institution had done was in effect a reprisal or retaliation for what they had done. And the court, the tribunal agreed with them, and in fact emphasized that, you know, they were within the ambit of the whistleblower policy that says that they can report. What they had done was send it to the court and also send it to the newspaper in Argentina. And the court agreed with them, and they were rescinded and walked away with a lot of money in compensation. So, you know, regulators need to be aware of that there's a need, it's best practice to have a strong, effective whistleblower protection so that staff members can feel, or third parties can feel comfortable to bring concerns forward. So we're going to move on now. I think I have 3 minutes. This is another case. Yeah.
Sorry, you know, just to say, we included at 5 minutes for when I did the introduction, so you're still good.
Oh, I'm still good. Great. Also, so I can tell another story then.
I think so.
Some of you may know about the Barclays Bank and the New York Financial Services Regulator about whistleblower. This was a very unusual case, and it was the chief executive of the Barclays Bank who had apparently helped one of his friends to get a senior position in Barclays Bank. And the board received an anonymous letter. The board received an anonymous letter alleging that there had been abuse of power, abuse of authority with regards to the recruitment. Of course, the MD was pissed. Now, you know, I can imagine him boiling and saying, "Who is this person who wrote this anonymous letter?" And so he reached out to the chief compliance officer at Barclays and said, "Look, I need your help to find out this person." And the compliance guy told him the right thing, that no, whistleblower, you know, unmasking a whistleblower is reprisal itself. So you shouldn't even think about this. But he still went ahead and contacted the chief security guy at Barclays, who used his contact at the FBI to try and find out the identity of the whistleblower. The whistleblower had posted his letter from somewhere in New York, and that's how the New York Financial Services Regulator was involved. And the FBI guys did the right thing. They contacted the regulator and said, "Look, this is the unusual request we heard." And there was an investigation by the regulator, and they issued over, I think it was maybe about $2 million fine, or there about $2 million. And in fact, that brought it to the attention of the regulator in the UK. And because of the presence of Barclays in the UK, obviously, they also issued a fine of nearly $1 million. Now, I think it worked out to about $900 something thousand. That was the fine that was issued for trying to unmask the whistleblower in that case. So let's move on. So these are just some of the common pitfalls that one needs to be mindful of, and we have spoken to that, you know, throughout the conversation we've had. Retaliation, which speaks to what we're talking about with Barclays, failure to act on reports or concerns. You have to send the right signal, and I mentioned earlier also the need for an efficient, effective ethics program. You need to have an investigation. Failing to provide procedural, substantive due process, using inexperienced or conflicted investigators, like the first did at the African Development Bank, and this was what led to having you know, somebody complain and then having another investigation. Inadequate documentation or failure to reach a conclusion. So if we move on to the next slide. I just wanted to share with you, just to give a sense to all this, you know, at the World Bank, these are some of the allegations we received. I call it just allegations. So these are not actually cases. These are allegations we receive, and we review, you know, on average on our internal side, about 228 in FY17. Financial year runs from 1st of June to end of July. In FY20, 281 cases. So if we move on to the next. So this indicates that out of like 220, we actually did 41 actual investigations. So the others were resolved, through a settlement agreement, through consultation and referral. But at the end of the day, we did 41 investigations. Next slide, please. This speaks to the process. So the process, we have an intake, and I mentioned the anonymous hotline. We have emails that people can come into or pick up the phone and give us a call. This is on our website, which is available to third party. After the intake, so we have an intake group of people, and then we have a preliminary review. During that preliminary review, we just want to find, is there a sufficient basis to proceed to a formal investigation? And then after the investigation, the decision maker is separate. The decision maker is a vice president, HR, who makes a decision on the outcome. And he makes a decision, and then a staff member may then appeal, or a third party who is concerned can go to our sanctions board. Okay, let's move on. Oh, I think that's I'm right on time, 9:42, right? Thank you very much.
Thank you. I think that's very interesting and raised a lot of interesting issues. And I'm sure that we already have one or two questions. I just want to remind everybody to please go ahead and put your questions in the Q&A part of the system. So there's a Q&A button for those who joined later. There's a Q&A button at the bottom. Please ask your questions, and we'll be taking questions all together after Mr. Booth's presentation. So I will hand over to Mr. Booth now, who is looking at something slightly different. I think your focus is slightly less on the workplace investigations. But just as Mr. Sonia has said, there was a lot to take away, general principles regarding investigations from that. And also, he has given examples. You do have lots of examples of regulators having to carry out internal investigations. And we have examples even in Nigeria from time to time. So it'll be interesting. So I hope there was a lot to pick up from that. So Alex, please go ahead. We'll hand over to you. Please go ahead with your presentation, and then we'll take questions at the end.
Thank you very much, Yinka, and thank you, Bamidele, for such an interesting introduction to the complex and fascinating world of investigations at the World Bank. Good afternoon, everybody. I'm going to take a slightly different, but I hope entirely complementary angle. And I'm going to speak a little bit as a practitioner in investigations around the world on behalf of Kroll. Kroll is an international business intelligence and investigations consultancy. And we're very often hired into sensitive situations in high-risk jurisdictions to provide precisely the external independent element that Bamidele touched upon in his own presentation. I think the place to start conceptually is just to sketch out what these investigations are often engaged for in terms of their objectives and their parameters. And then I'd just like to take 10 or 15 minutes to descend to the level of investigative techniques and to just talk through some of the investigative approaches that we typically use when we're called in to support our clients in sensitive situations. If we could go to the first slide, please. That's correct, yeah. The independent investigations by people outside the organization are really quite vital. And they're vital as a deterrent, as Bamidele said. They're also vital to assess what has happened. And they're also vital because an external investigator can be as free as possible from some of the internal dynamics and indeed some of the wider political dynamics that can be at play in an investigative scenario. So we're very often hired into some very sensitive scenarios precisely because we do not have an office in that country. And if you look at Angola or DRC or Ethiopia or some of the more difficult operating environments across Africa, we're very often brought in as external investigators to support clients there because local audit firms or indeed internal teams can prove to be very vulnerable and very susceptible to some of the pressures that are at work in those very challenging environments. First thing for us usually is that investigation team for any non-routine investigation will be formally instructed through a lawyer, through the client's counsel, and that's so that we can get privilege in place. And then in terms of the approach, there are typically three practical components. The first part is the interviews, and we'll come into those in a little bit more detail in a second. But interviewing is crucial. It gives you a real sense of the context and the participants. But nevertheless, I think what I would say is that increasingly in the modern world, the core of any investigation is going to be the review and the assessment of electronic and accounting documents. And that's because the technological evolution has really deeply and permanently altered the way that businesses keep records. And in bribery and corruption cases in particular, the majority of the facts that we're going to look at will typically be found inside corporate networks, inside email servers and electronic devices. Accounting systems these days capture millions and millions and millions of transactions. And part of what we're going to talk about is the best way to analyze and search that data. I think the fifth thing is that an investigation will often require a site visit, sometimes more, sometimes less, but usually at least one or two. And it will usually be an iterative approach. Of course, some information gathering can be performed centrally, and that will certainly serve to reduce costs and reduce the resources required to the extent that you can get yourselves a head start by reviewing whatever data the client can send in advance. But really, in my opinion, to make a meaningful investigation, achieve traction, and uncover findings, particularly in high-risk jurisdictions, needs to involve a trip to be on the ground there. And we do that all the time at CROL. The first visit will typically be to collect information and understand the context, understand the dynamics, understand the personalities involved, and some of the stresses and the vulnerabilities they may be under. Then we'll return to the office, and in a safe environment there, we can review everything that we've gathered and analyze the information we've collected. And then sometimes we'll return to the site to cross-reference some of our preliminary findings, to carry out some testing of particular transactions that we may have identified as being of interest, and to do another round of interviews to confirm or dismiss any initial findings. In our experience, we're a global company and we have offices all over the world, but in our experience, I would say it's better to have a consistent and small group of experienced staff who can travel to multiple sites rather than rely on diverse, multiple affiliate offices. And I say that because as you gather the context and as you cross-reference the material, you become increasingly familiar with the industry or the sector or the participants of your target. And having a small team of experienced people who could hold all of that information and work closely together is a much more effective way of building hypotheses and testing them and cross-referencing and joining the dots than it is having a large group of people who are dispersed across the world and maybe are not in a position to see the larger picture. So those three steps are the outline of a typical investigative approach. And now what I'm going to do is just take each one in turn and have a look in a bit more detail. If we go to slide 2, please, which is going to be about interviewing, one of the first thoughts when we conduct an investigation on site is to figure out where is that useful information going to sit? Who's going to hold that information? And we call those people the custodians of the data. And the interviews with these custodians are going to give us some really valuable background and context. And they're going to give us some indications of the corporate culture and the attitude towards ethics and compliance within the institution. We would typically ask about vetting procedures for the use of third parties and agents. We would ask about interactions with government departments and government officials. We would ask about any red flags and any instances where people may be aware that bribes have been requested or paid. And we typically ask some very open questions about areas for compliance and improvement. In terms of identifying and selecting the custodians, on site, in country, we typically aim for around 4 interviews per day. That's not a hard and fast number, it's an estimate based on experience, but it's typically around 4 interviews per day. Now you have to admit here of the human factor. You can't always determine people's schedules. Some people won't be available, some people will cancel. On the flip side, of course, some people who you weren't expecting to be useful informants will tell you far more than you expected. And so there has to be an element of flex and agility when you're identifying and talking to these custodians. The third thing is the composition from the interview team, the composition of the interview team. We'd typically deploy people from quite a wide cross-section of disciplines. And we will have in our team people who have a track record and professional familiarity with the legal world, the forensic accounting world, the intelligence gathering world, and the particular industry or sector that we're trying to understand. So we have a mixed team that bring a range of disciplines and skills and viewpoints to the question. Local languages are, of course, extremely important and very useful to have a local language speaker in our team. It's not always possible, but where we can, we like to make use of that. I think at the headline level, most multinational companies that we work with and work for and investigate on behalf of typically have either English or French as their operating language across the globe. But having in the room somebody who's familiar with the local language gives you an added degree of access and interpretation to some of the nuances or maybe some of the reluctances in the people you're interviewing. In terms of the interview strategy, as Bamidele said, for legal reasons, but also for reasons of good and proper conduct, and indeed for effectiveness, in fact, it's really important to demonstrate a lack of bias, not to rush the interviews, to ask very open questions. To the extent that you might later on in the process ask open or closed or leading questions, it's really important that you ask each type of question in a logical sequence to maximize the development of the information you're going to get. But throughout, it's absolutely critical and imperative that you remain respectful, you remain open, and again, as Bamidele said entirely accurately, we're not in the business of accusing anyone of any crimes. We're here as an independent, external, fact-finding exercise. Maintaining proportionality is important and is part of that. We're very often going to follow a phased approach. So our first phase will be a very open-ended review of existing compliance procedures. And then to the extent that we identify any areas of concern, we will drill down on those areas and bring a slightly more assertive focus when we have evidence in front of us that requires further explanation. And of course, the proportionality and the depth of the exercise will vary depending on whether we're carrying out a routine compliance review or whether we're acting for a client who is facing questions from a regulator or indeed from a prosecutor, where the investigation will have a much more targeted set of questions that we'll need to try and address. And then I think the final point is the recording of findings of interviews. It's, of course, good practice and very useful to have somebody not involved in the questioning, but sitting quietly to one side and taking very detailed notes, so that the questioners and their teams can concentrate on their interview subjects and the substance and the tone of the responses, and not be distracted too heavily by taking notes. Note taker is an important participant, even if they say nothing much throughout the course of the interview. And in terms of reporting the findings, again, for reasons of legal privilege and client privilege, we will address our findings to the client's lawyers and counsel, and we take great care to use clear language and rely solely on facts. That's the interviewing. That's the first stage. If we can switch to the next slide, please. We'll have a look now at the next stage. And the document review and e-disclosure, as I mentioned at the beginning, is a really central point of investigations in the current information climate. The document review will differ depending on whether it's a compliance review or an investigation for a regulator or a prosecutor. If it's the latter, we may need to obtain seized evidence and follow a scope defined by the prosecutor. In terms of the actual data collection, the first point is to obtain a really good understanding of how that particular organization stores its data. What is the purpose and the operational function of the systems, and how does each custodian that is of interest interact with those systems? The data needs to be collected and hosted in a form that is suitable for review. And of course, it's usually faster and cheaper from the client perspective to collect custodians' emails directly from the corporate email server, which will often be a Microsoft Exchange platform or Lotus Notes or something equivalent to that. I should add, of course, that in most of our cases, our clients are large multinational organizations who've suffered a fraud or a corruption event inside one of their operating companies or inside one of their subsidiaries. So they usually enjoy full rights of access to the server by virtue of being the parent company or the controlling shareholder. And essentially there's a three-stage hierarchy to the scale of this exercise and the depth of investigative coverage. The first is to retrieve emails and other materials from the corporate server. The second is to do that, but also to copy files from individual laptops where our client enjoys rights of access as the employer or the shareholder, the owner of those laptops. But the third point is forensic imaging. And forensic imaging takes this a little bit further and is more than merely copying files. Forensic imaging captures the entire hard drive. And that will include, of course, live files and documents and email correspondence. But crucially, it will also include deleted files and metadata and fragments of files. And that's a really deep dive capture. And in fact, the metadata alone can be very interesting from an analytical point of view. If you see that somebody has been deleting files and you cross-reference that against certain events in a timeline, that can be very illuminating. And the forensic imaging is really quite appropriate to requests from prosecutors, but could be also very appropriate to incidences where clients have suffered thefts of information or the breaking of anti-compete clauses. We're just concluding an investigation in the African market right now where a couple of individuals within the company planned to set up a competing business, and prior to their departure from our client, they planned and prepared to steal some fairly large data sets and to take with them as they left a whole list of clients. Now, they've denied this, but what we've been able to recover from the forensic imaging of their laptops is months and months prior to their departure of the company, they were working together to export data and also to even design letterheads and design logos for their new company. Now, all of this had been deleted from their laptops, but with some fairly substantial forensic imaging, we were able to recover most of this preparatory work and build a very well-evidenced timeline of their preparations to steal this client data set. Data privacy is a really important area. I'm not a lawyer, but we work very closely with lawyers and we take data privacy and protection very seriously. I'm not going to comment in detail here because there are lawyers to our left and right as we speak, but suffice to say that people and systems in multiple locations are the norm for these investigations. Fraud and corruption and bribery, these days particularly, almost never takes place in a single jurisdiction. Everything we see is cross-border, and so we must factor in the various and differing rules across the different jurisdictions. In many European jurisdictions, for example, we see that personal data is heavily protected, and there are restrictions against certain cross-border transfers of data. It depends on the location, and indeed some European countries restrict specifically the export of data and data flows to the US. In our experience, really where data is stored and housed is generally the best place to conduct the data processing. And that comes back to my earlier point that where it's possible, our strong preference is to be on site, not only in terms of our investigative progress, but also to be as compliant as possible with data protection and data storage rules. The next step in terms of once you've gathered the data from the collection phase, we're then going to move to the data onto a review platform, and that will allow documents to be searched, not only by keywords, but by metadata, as I mentioned. And there are some very, very powerful and sophisticated tools that we can use to multiply our reach and our understanding of large data sets. One of which some of you may know is relativity, which can search by cluster and by concept. Keyword searches are for names and dates and locations and certain amounts remain the bedrock of an investigation and document review, but they're increasingly inadequate. Firstly, corruption has its own language, and searching keywords gets you only so far. Certain participants in a fraud or corruption in all different kinds of local markets will disguise their language. They will use local slang, they will use street slang, they will use code words, and there are any number of ways to disguise keywords. It's no longer the case that you can obtain a data set and search for keywords such as bribery or the name of a certain official. The other reason keyword searches can be inadequate is because not only do they produce too much information, but they may also miss vital information. There's a bias towards keyword searches because our experience of internet search engines, such as Google, has trained us to think that the search on a certain term will deliver the most relevant results first. And of course, in Google, we have the benefit of the Google algorithm, which delivers the most relevant or the most recent or the largest number of hits at the top of our search page. That is an inbuilt algorithm to Google, and a lot of people don't realize that the same assumption cannot be mapped to keyword searches. And therefore, the risk of keyword searches is that they will return a number of hits that is simply too voluminous for even a full-time team to make sense of. There are a number of quite smart alternatives to keyword searches in terms of pattern analysis. I'm going to just give three quick ones, which we use often and we find extremely useful in interrogating and analyzing large data sets for investigations. One is concept analysis. And in this case, we're going to group documents into conceptual clusters. So we will produce a set of hits in our research which relate to a particular subject or a particular theme, and they will be organized and gathered by topic rather than by sequential order or rather than by author. The second is metadata. And metadata is really interesting in pinpointing custodians who've shown suspicious behavior. And there's a number of triggers that always trigger our interest when we're looking at the metadata. One is if you see materials frequently blind copied to external domains. Another is the renaming of documents under innocuous names. Another is the disguising of IP addresses through using proxy servers. Another is using different browsers to the corporate standard. And another is using instant messaging services to send important company documents. So none of this would be visible from a data set at the first level. But once you begin to interrogate the metadata and match metadata and use the metadata to illuminate patterns of behavior, you get a very good sense of not only what somebody is trying to do, but also what they're trying to hide, and also what they would prefer their organization not to see. And the third area of pattern analysis is communications flows and communications networks. If you map out the email traffic between person A, person B, person C, person D, and then you represent it visually, you can very quickly get a sense of who's communicating with who, and what does that look like from a distance, from a high level. In most of our working lives, we actually, in a corporate setting, we're communicating most frequently with, let's say, the 10 people above us in the hierarchy and the 10 people below them in the hierarchy. If we're communicating with someone higher than our boss's boss, very often our boss will himself be copied in the email. These are not hard and fast rules, but I'm merely suggesting that it is possible to spot unexpected relationships by virtue of the volume and the direction of email traffic. Unusual patterns which are less linear. It's quite unusual for the most senior person in an organization to email directly the most junior people in that organization without reference to their line managers or the middle management layer. It's not in itself a sign of anything suspicious, but it can be an interesting anomaly to see again how people communicate and the frequency of their email traffic when viewed across and referenced against certain timelines. We'll move now to the fourth component, if we can have the next slide, please. This is the last one, forensic accounting. And increasingly, financial input and financial data is vital in investigations. It's necessary to factually verify the answers that are given in interviews, to confirm hints, and to understand more about what has been picked up in the document review phase. Transaction testing is when we take a sample of payments from within an organization or from within a certain function, let's say paying a particular supplier, paying a consultant, paying a fuel supplier, and we test them. We take a sample and we check for each transaction. Has it been authorized? Has it been accounted for properly within the company's systems? Are these transactions to the company's benefit? Do they conform with the compliance process? And of course, do they conform to the country's laws? And very often anomalies that are detected in that sample can then be used to help guide your searches further. When we analyze these large data sets, we have different mechanisms of analyzing and mining them. We need to stratify and summarize and age the data and look for gaps and duplicates. And there's essentially two steps: data analysis and data mining. Data analysis is a high-level view where we search for anomalies. We're going to stratify the data. We're going to look at totals, averages, the top number, the bottom number, and any outliers. And we'll run some statistical analysis to identify those outliers. Some of them sometimes may prove to be unfounded or even fictitious transactions. Data mining is the same thing in the other direction. We'll pick a particular transaction and then we will screen that transaction at great depth against the predetermined set of high-risk situations. And we'll take a particular example through the life cycle of the transaction. Again, what we're really looking for is anomalies or areas of the highest risk. And some of those high-risk transactions are, you might see multiple gifts to a single individual. You might see payments to suppliers made in cash. You might see transactions with politically exposed persons. You might see payments to vendors who are not pre-approved or do not appear on the vendor master list. You might see payments that are consistently just below a certain level at which authorization is required. You might see missing descriptions for payments, or you might see people entering and re-entering inactive accounts and making adjustments there. All of this will be captured and reported. We'll have a summary at the front, and then we'll back into the details. The reports will be addressed to the lawyers. We will try to quantify the scale of the losses, which is, of course, a rough exercise based on the data sets we have seen. Sometimes you can extrapolate from that. Sometimes you have to interpolate. Often it's not clear. And then we'll make some recommendations for a remediation plan. If we can go to the next slide, I'd like to conclude with just some observations from the field, and just to give you a brief snapshot of some very recent investigations we've run, just to put some flesh on the bones of the techniques that I've been talking about, and then a very, very brief look at the shape this field is taking as we see it. The first case I should mention was for an international private equity fund who had made a number of investments in Nigeria. One of those investments was in a portfolio company that, by virtue of its business sector, had a high requirement for diesel fuel. And the private equity company received a complaint via a whistleblower, via a series of anonymous emails, that the diesel procurement operation of the portfolio company was being heavily defrauded. Suppliers were not supplying the volumes of diesel that our client was paying for. Some diesel was being stolen at the point of use. Some was being diluted. And a number of junior and mid-ranking employees within the portfolio company were complicit in this operation. We deployed a team to the site of the portfolio company. The whole exercise proved to be an enormous eye-opener for the client, because the client was sitting far away from Nigeria in its international headquarters and had allowed a situation to develop where there was very limited visibility on the portfolio company. And we used a whole range of data analytics techniques that we were just touching on earlier to identify who were the biggest suppliers of diesel, which parts of the business were being properly supplied by the diesel suppliers, which employees may have hidden or undisclosed family or residential linkages to the suppliers, and roughly speaking, what was the quantum of the loss. That was an investigation which proceeded along a very classical track. We, because our client was the owner of the portfolio company and therefore the owner of its HR and IT infrastructures, we were able to review the emails of some of the key suspects. We carried out a range of interviews internally and externally, some with the employees of the company and some with members of the diesel supply community. Incidentally, and a point of interest, a point of human interest, the whistleblower himself proved to be entirely inaccurate. He himself felt aggrieved, and his complaints appeared to be largely motivated by the fact that he felt undervalued by the business. And much of the substance of his allegations that came to us through the whistleblowing channel proved to be inaccurate, or in fact, in some cases, entirely fantastical. However, the exercise of carrying out the fraud investigation that was triggered by that whistleblower did in fact identify systematic irregularities in the diesel process. So it just goes to show that sometimes what has opened the door isn't a very sensible, isn't a very solid guide to what you're going to find once you're inside the room. The second one is a topical example from Kenya. And those of you who caught the preamble to the conversation heard Bamidele and I talking about the health sector in Kenya. This is not related to the COVID pandemic, but is a much earlier example where a government department in Kenya put out to tender a contract to supply a number of specialized mobile medical equipment, which could be deployed into the field, into rural areas far beyond Nairobi, and to try to extend the reach of health coverage in rural areas in Kenya. The contract to supply this equipment was put to tender. 6 companies bid to supply the equipment, and the winning bidder was selected on the basis of its service offering and its fee quote. But on closer examination, we uncovered the fact that of those 6 companies, which were ostensibly Kenya-registered entities, all 6 parent companies above the Kenyan level were located in offshore jurisdictions. So the Kenyan bidding company was, for example, owned by an Isle of Man company, which was owned by a Seychelles company, which was owned by a Mauritius company, etc., etc. And when we pierced that corporate veil and peeled back the layers of ownership, we found that ultimately all 6 companies were owned by the same wealthy Kenyan individual. So what appeared on the surface to be a competitive bid had in fact the same beneficiary at the top of the tree who could not lose, because whichever of the 6 bidding companies was selected by the procurement department, that individual was the ultimate owner. So that was an investigation which required a lot of interviewing to penetrate who was really behind the award of this contract, both inside the awarding authority and outside in terms of Kenyan businesses which were in fact, effectively functions of an offshore beneficiary. The third one is a well-known example now. It's in the public domain. This relates to the efforts of the Mozambican government to raise funds on the international debt capital markets, ostensibly to finance a commercial fishing fleet, some maritime infrastructure, and also the development of a maritime exclusion zone to protect Mozambique's nascent natural gas industry. The money was raised on the debt capital markets. It was about $2 billion, and it carried a guarantee from the Ministry of Finance of Mozambique, which enabled them to borrow to that extent. Actually, what transpired was that the 3 project companies who borrowed the funds were owned, in fact, by various different organs of the state, including the pension fund of the National Intelligence Service of Mozambique. The business plans which were supplied to underwrite the borrowing were inadequate, and in fact the commercial prospectivity of these ventures had never really been properly and rigorously tested. So when these undisclosed sovereign debts were discovered, they had a material adverse impact on the economic stability of Mozambique, and the IMF paused lending and budget support. and many of the other donors followed the lead of the IMF and similarly paused their lending and budget support. And this put on freeze something like 40% of Mozambique's budget. The IMF engaged Kroll to conduct a large forensic audit. And again, we, to varying degrees, we followed the three different strands I laid out a little bit earlier. This is a very good example of the need to cross-reference between materials that are available in the public domain, materials that are to which we enjoyed rights of access by virtue of our relationship with the client and the collaboration from certain parts of the Mozambique government architecture who wanted to resolve this transparently and achieve a degree of reset with the international community. And also, of course, interviews. And you'll appreciate that the diversion of funds from a sovereign debt raising by a ruling party is a highly sensitive issue. And this required us to be extremely agile and to observe some very important operational security parameters as we were deployed into the field. I hope those three give a snapshot of the sort of scenarios where independent, external, professional investigators who have experience of challenging jurisdictions can be brought to bear. And in terms of looking ahead, I think some of the lessons we're seeing and some of the conclusions we're forming from the front line are that fraud is becoming more and more complex. It's no longer the case that fraudsters will simply seek to fly out of the country on the next plane to Dubai with a suitcase full of cash. There's some extremely complex layering being adopted to launder funds out of companies and governments which have been defrauded. And we also see an increasingly dual use of legitimate counterparties. So to my point earlier about screening approved supplier lists, less and less often do you see anomalous suppliers suddenly appearing. What is more often the case is there's a sophisticated collusion between an internal employee and an external supplier, and they will ensure that a registered extant supplier is adopted as the umbrella cover for any suspicious payments. Looking at the industry more widely, I think we can see an evolution of the areas of interest of international regulators. Of course, historically, the key culprits from an FCPA or a regulatory perspective had been the oil and gas and the natural resources and the mining industries, going right back to the creation of the FCPA in the mid-70s. Then I think we saw the spotlight shift to industries such as pharma and financial services and power and infrastructure and automotive. And what I think we're seeing now in the current climate, and certainly the types of investigations that are being brought to Kroll now are increasingly in the fields of human rights, sexual harassment, employee wrongdoing and employee behavior, and environmental degradation. And so that is a shift and an evolution in the thematic sense of where our investigations practice is being asked to intervene. And I think the next step will be for us, I hope that we will be engaged on behalf of some of the larger donor organizations to have a look at where some of the COVID-19 rescue funds have been deployed. And that brings us neatly, ladies and gentlemen, back to the beginning of our conversation with Bamidele. So I'll stop there and say thank you all very much for your time and your interest.
Yes, thank you, Alex. Thank you, Mr. Sawyer, as well, for your respective presentations and for sharing your insights and your experiences with us on this subject. I've certainly found the presentations useful, and I'm sure so has the the audience, especially given the nature of questions that we've been seeing in the Q&A chat box, which I'll get into in a bit. Alex raised an interesting point about the nature of investigations that CRAW has been involved in recent times. And, some of these sort of themes are also what we are seeing here, especially as it relates to employee misconduct, whether in the context of fraud or in the context of harassment and similar issues. There's been several questions about whether we will be sharing the slides. Yes, we will do that after the presentation. We will also share the recording of today's session. This takes me to the first question, and I think this would be for Mr. Sonia. It says, I believe not all investigations has timeline. What timeline can you give a complex financial crime investigation, having in mind the peculiarity of Nigeria and difficulty with record keeping? I think that the reason why this question is being asked is because our criminal laws says that there is no time limit. The limitation periods that are otherwise applicable to commercial contracts are not applicable to criminal offenses. So I think that's why this particular person, Mr. Shehu, is asking this question. So if Mr. Kusanya can take that, please.
Thank you very much for that question. Let me just, before I answer that question, quickly say, before or long before now, we never used to hear about sexual harassment in the news. But as Alex mentioned, these are some of the issues that you see in the news. If you recall, the British guy who was the MD at McDonald's, his case was reported in the news, and that was one of the reasons why he had to leave. But let me circle back to the question. Every investigation has its own timelines, depending on the complexity of that investigation. But every investigation needs to be done promptly. This is best practice. The reason why, so irrespective of the legal limits, time limit, I'm not speaking about time limit. I'm talking about the need to have a fair, unbiased investigation. Remember, during an investigation, witness testimony is very important. If investigation drags on for so long, the ability of witnesses to recall is jeopardized. Secondly, is about gathering forensic information, right? The longer this investigation takes, right, the higher the possibility of evidence being destroyed. And that is why, it's important. And this is emphasized by the court as well, in the US, in the UK as well. And I don't know too much about Nigeria's jurisdiction, but I know that in the US and in the UK, courts have voiced that opinion about the need to have a prompt investigation. Of course, if you are doing a fraud investigation, it could last years, right? But if you are doing a sexual harassment investigation, it shouldn't be lasting years. It should be taking 6 to 9 months, no later than 9 months. So this is what I'm referring to. I hope that answers the question.
Yes, it does. Thank you. The next question will be for both of you, actually, but I'd like Alex to take a shot first. He says, kindly explain how consultations are made in the course of investigation. So if Alex could shed some light on that in the context of external investigations, while Mr. Sonia looks at it from the perspective of internal investigations, that would be helpful. Alex?
Yeah, sure. Just to clarify, what do we mean here by consultations?
I think that it was this question was asked on the basis of one of the discussion points from Mr. Sonia. In one of your slides, I think you spoke about internal consultations before an investigation is being triggered. That's my own sense of why the question is being asked. But the the person that asked this question hasn't provided any more information.
You know, I think if the person feels otherwise, they can always type in a further question on the chat, if that's okay. But we'll take it as discussions before you launch an investigation. So does Alex want to say something first?
Sure. For our purposes, we do have a consultative process before we're brought in. As I mentioned, we're usually engaged by the client's lawyers. So they will have a sense from the client of where the legal objectives lie and the legal vulnerabilities. They will then consult with us as to what we think is possible from an investigative point of view. And the most important things for us, I think, are to be very clear about the limitations, to be very clear that an investigation will not always be conclusive. It will not always result in the reduction of a fine from a regulator or the negotiation of a DPA with a prosecutor. We're concerned really from our perspective only with the facts, and the initial consultations from our perspective will very often dwell on that so that we can make sure that we are given an environment in which we can work and that the data we need to proceed will be made available and shared with us, and that the working environment will be conducive to delivering a thorough and professional and rigorous investigation. So we do decline work on that basis, and sometimes the initial consultations will dwell on that. We need to be comfortable that there are no preconceived ideas on the part of our client as to what the outcome will be, and that we will not be pressured to achieve a certain outcome in a certain direction. So for us, the initial consultations are about achieving mutual clarity on the mandate, on the scope of work, on the terms of reference, and on the concrete deliverables, so that everybody's on the same page in terms of the objectives and the strategy.
And if I may just add to Alex, all the principles that Alex has enunciated, just transfer that to basically what we do internally as well. Investigation is a serious matter. It's not something that we take lightly. Whether we're investigating fraud on our projects or whether we're investigating our staff members. So there's an initial, before initiating an investigation, there's an initial consideration of whether there's a sufficient basis to launch an investigation. And this will include the scope of the investigation. What are we trying to find out? What are we trying to ascertain? So these are the issues that we deliberate on. I also wanted to point out that our own tribunal, the World Bank Administrative Tribunal, it's a de novo. It's the only judicial body within the World Bank. And it looks at an appeal of an investigation from the beginning, de novo. So therefore, those facts will be looked at whether they are there, whether those facts that are claimed are there. We don't launch an investigation based on rumor, for example. It has to be sufficient basis to justify. And those are the initial consultations that take place before we launch an investigation.
Okay, thank you so much. This takes us to the next question. How do you ensure that the confidentiality of the information given is maintained? And I'd like both of you to look at this question from the perspective of recommended practicalities. Let's leave the law aside. What are your recommendations regarding how confidentiality can be maintained? Because this seems to be a big issue for a lot of whistleblowers and persons that are involved in an investigations, including individuals that are asked to provide testimony in the course of gathering data and information, etc. So it will be helpful to hear your thoughts on what you think would be most practical. Both of you, that question is for both of you.
If I may go first.
Sure.
No, this is an issue that we grapple with. So this is not new, right? So let me just start by saying that. So we do have, like I said before, and I think it's best practice. I'm sure Alex will agree. We have an hotline, and we permit making anonymous reporting, right? And we have the whistleblower we protect. But the truth of the matter is, these are concerns. These concerns will not go away. From a practical point of view, when a staff member brings concern, or if a third party brings concern to us, and they are saying that, look, I want to be anonymous because I fear reprisal, I fear retaliation, what's going to happen to me? Those allegations, we will look at it to see whether we can substantiate those allegations without the need to disclose the identity of the person, which is possible. For example, cases in which we can have independent, verifiable information apart from the testimony of the person who's coming to us. But we have even gone the extreme, and this is practical. So we're not speaking law here, and we're speaking practicality. We had in Ukraine, we had a project in Ukraine that we investigated, and we were only able to find misconduct. This was a big fraud on one of our projects there. We're able to find, but only because somebody who used to work for that company came to us and gave us all the information. We couldn't use that information without disclosing the identity of this person. And we made a decision, this goes to the very top as senior management, that we're going to bring this person and their family to the US. And, I'm not sure to what extent a regulator or organization can do that, but this speaks to our own power and privilege as an institution. So we're able to secure visas, migrant visas, for this staff member and his immediate family to relocate there, because we could see that there was a fear. We established that there was a fear that this person might be killed in Ukraine. Now, we did that, right? But that doesn't mean that this will apply in all cases. This was an exceptional incident. So these are some of the practicalities, but the truth of the matter is there are limitations to what we can do, especially if we are only going to rely on the evidence of the person who is coming forward.
Thank you. Alex?
I would agree with Bamidele entirely, although of course we can't match the World Bank's firepower in giving people new identities and new places to live. I think it comes back to the fact that we are, and the lawyers we work with will be external and independent. I think whistleblowers and informants and sources need to feel fully confident that what they're going to tell us will be heard dispassionately and will be heard by people outside the hierarchies of the institution concerned. That's something that we alluded to earlier when we touched on the Akinwumi Adesina investigation inside the AFDB, in terms of, there will be circumstances where people are putting themselves at risk to make reports. Maybe not risk to their health and well-being, but potentially risk to their future promotion prospects if they upset the prevailing climate inside an institution. So I think our character as external, independent listeners goes a long way to creating a climate in which people feel able to talk and to share confidential information. The other thing I think is to take very seriously the position people put themselves in when they tell you that. We have a duty as listeners and as investigators, in the same way I think that journalists do. We have a real duty to protect the confidentiality and the identity of the people who talk to us. And we take that very seriously. And when I mentioned the mixed composition of our investigative teams earlier, I talked about lawyers and forensic accountants, but we have people who come from a background in investigative journalism or counterterrorism or intelligence, who are very skilled in creating the climate of empathy and respect that whistleblowers and informants will need. Well, A, they'll need that to speak freely and to share valuable intelligence. And B, we have a duty to provide that, to protect their identity, to make sure that anything they tell us which is used in our reporting can't lead to them being identified as the original source. And we take that really seriously, and we work quite hard in our interview scenarios to establish a climate and a rapport where people feel that to be the case.
Okay. Thank you, Alex. There's a question here for Mr. Sonia about the AFDB investigation, but I'll come back to that in a bit. Someone has asked you, Alex, a question here that says, Mr. Alex, I want to know your experience regarding investigations concerning multiple jurisdictions, especially because you are a private sector investigations and intelligence firm without government powers. I'm asking these as a result of my experience investigating multiple jurisdiction cases where countries will need mutual legal assistance treaties, though I rely on information or on informal contacts to fast track my investigations and then come through thereafter to ease and fast track the investigations.
Yeah, it's an excellent point, and I agree with it. Investigations like the frauds themselves and like the companies themselves that suffer the frauds are inherently international, and very little of what we do is confined to a single jurisdiction. The acts of fraud themselves seek to exploit misunderstanding and poor levels of information sharing between jurisdictions. Just to take one example, you know, if you think of, let's say, the axis between Nigeria and the UAE, for example, a lot of illicit capital which is taken out of Nigeria finds itself in the UAE. Now, the UAE law enforcement and intelligence agencies will know how that money is being spent. It is being spent in the accumulation of property portfolios and luxury villas on the Palm Resort, and private jets and private yachts. They will know how the money is being spent, but they will not know how that money is being generated. The Nigerian axis may have the opposite view. In Nigeria, it will be well known how a certain fraud has been committed, how a certain individual has raised money, who they are, how they're networked, how they're connected. But the money will have left the country, and the spending patterns and the asset accumulation of that individual may not be visible in Nigeria. So it's really critical that the dots are joined and that there's a high level of international collaboration. And that really is our bread and butter, because we have a network of offices around the world. And on any given day, on any given investigation, we're working with colleagues from those offices. So if I'm instructed by a Nigerian client to support them on pursuing a fraudulent asset, you know, I can call my colleague in Singapore who will know the right lawyer to have that asset frozen, and vice versa. So it is about international connectivity. And I think really the investigative efforts have to follow the contours and the patterns of the frauds themselves, which are highly international. There was a recent effort to subvert and to hack the central bank of a small East African country. And that effort was, you know, the target was sitting in East Africa, but the effort was mounted from 3 or 4 different centers in Eastern and Central Europe. And the participants were drawn from something like 10 to 15 nationalities. So not only the way the crime is structured and committed, but also the nationalities of the participants, and of course the flow of the proceeds and the flow of the funds that derive from the crime, all of these are international.
Okay, thank you, Alex. There is a question here about crimes that are not related to finance issues. The question says, and I think we should ask it because it throws up a different dimension to the discussion. The question says, it appears that the two presenters limited their presentation to finance issues only. Can they relate it to other crimes like medicinal products, hard drugs, etc.? Do you have any insights on that subject?
Bamidele, do you want to take that first?
Okay, I'm going to try. So basically, the principles. So, I started by saying, when I started my discussion, that these principles we're talking about equally applies to other types of investigation. So the person is talking about the question the person is asking is about, investigating, say, mislabeling products or selling medication that are not genuine, right?
Yes.
This investigation will, and we have seen situations here where we are funded, and I'm sure we're going to see a lot of it after the COVID goes away. We have paid for, in a number of developing countries, we have paid for, even in Kenya, where I used to live, and Alex may have heard about it, we paid for testing equipment, we paid for all these things, right? And they've been diverted or replaced with something that is not genuine, right? So this, the process for ascertaining the facts will be the same, which is basically going into Kenya and speaking to the actors and doing forensic audit of the Ministry of Finance, the Ministry of Health that we have provided money to. The same principles that we've been speaking about in terms of, how do you initiate that investigation? What are you looking for? Who are the possible targets in terms of witnesses? How you are going to conduct the investigation and check their books? Those principles will also apply in this case. So the other thing I can just also mention is that I don't know to what extent that this is covered, but referral to police authorities. So sometimes when we do this investigation, it also goes against, that's what has done, is also in contravention of the national laws. And so therefore we may make a referral, the institution might make a referral to the police authorities as well. But this is a judgment that we make. We decide whether it is necessary to do that or not.
Thank you. There is a question here about, okay, it says increased remote working presents some challenges in terms of the adjustments to the process of investigations. What are your thoughts on the new challenges and emerging trends in investigations? And I think that this is an important question because I certainly worked on an investigation earlier in the year and submitted my reports about at about the middle of the year. And the client, came back and was concerned about the timing for undertaking the various remedial actions that we had recommended. Given the lockdown, the fact that employees are still working from home, they were concerned about whether they are actually in a position to be able to follow through the outline in their code of business conduct, given the current climate or the new normal that we are in now. So I think this is an important question, and I'd like both of you to share any thoughts on it.
Shall I take a stab? Look,
yes, please.
Adola, I think you're absolutely correct. I think it is a serious restricting factor on the implementation of remedial measures. I see that right now. And I also think it makes it very much more difficult to effectively deploy investigative teams into the field. As I mentioned, the first step in terms of gathering context, gathering information, receiving data from the client and reviewing that data, that can all still be done. And we're still running at full speed in many investigations at that stage. where the client can share with us large data sets for interrogation and analysis. Where I think we are seriously compromised at the moment is in deploying teams on site and conducting face-to-face interviews in jurisdictions around the world. And as I mentioned, that's an integral part of the process, because the reading of the nuance and the cross-referencing between hard data sets and what you're learning in the interviews is a really important part of the process. And at the moment, we do have a number of large, sensitive investigations which are proceeding slowly, but are effectively on pause because we can't deploy our teams into the markets. So I think it is a serious limiting factor. And I think it will provide and present opportunities for further irregularities to take place inside companies and inside institutions, while the levels of supervision are loosened.
I completely agree, Alex. I can only just say that from the World Bank perspective, I think I mentioned it also at the beginning, how we deploy money now with little checks and in terms of accountability. And in fact, when somebody raised it at a meeting that, look, these guys were just giving them money, and the reply from somebody in senior management is, we'll ask for receipt afterwards, which we don't do. And just to add to that as well, a lot of supervision we do on our World Bank Group projects, we are unable to do now by physical inspection. We now do it, we do mission online, virtual mission. So you want to visit and see the school that is being built in Uganda. So what you do now, you have them send you a picture, or and of course, we know what you can do with that. You can make it up, right? So these are some of the problems associated and challenges associated with the pandemic. What we have tried to do more is a lot of training. We've diverted a lot of resources into external and internal training on anti-corruption, on compliance. But in terms of actual investigation, that has been impacted a lot by the lockdown. Thank you.
Okay, thank you both for that. I think we can only take a few more questions before we close. There is a question here that says, can we take this discussion beyond workplace and to cover protocols of investigation and compliance of licensees, especially as regards antitrust and corporate governance in a regulated sector? Does either of you have any comments on that, please?
I think that might be one for the lawyers.
Sorry, can you repeat the question?
He says, can we take this discussion beyond workplace to cover protocols of investigation and compliance of licensees, especially as regards antitrust and corporate governance in a regulated sector?
I'm going to try and take a stab. So in terms of our compliance functions, we don't, what we have is basically dealing with, our lenders, which are basically our government. Now, in terms of the private sector, like our IFC business, right, we do the obvious integrity due diligence, and we facilitate conversations around that for training, for those people to know our code of ethics and our code of values as well. We do that, but apart from that, we're very limited in our exposure, to external parties with regards to that question. So I hope I've given some suggestion. I don't know whether I answered.
Yes. Yes, thank you. I think I'll just like to add by saying that, the protocols would vary from institution to institution, from regulator to regulator, and from sector to sector, depending on each individual regulator's requirements from both a legal and a practical perspective. So those protocols will vary, but those protocols, I believe, would also take into account what the law says about the entities that these regulators regulate, and how they are meant to be regulated. That would be my view on the subject. We are almost out of time. We have only a few more minutes, so I'll take just one question more and then we will close. There have been several questions about whistleblowing. So I hope that if I ask one of these, the answer will cover quite a number of questions here on whistleblowing and related matters. This question says, how do you deal with whistleblowers that send wrong information? In other words, is there any repercussion for spurious alerts by whistleblowers?
If I may just take that quickly.
Sure.
In terms of the World Bank Group, right? We do say, it's in our rules, our policy, that a whistleblower has to make disclosure, right, in good faith. So good faith disclosure, good faith report. And if that is not the case, we consider that as a misconduct, as it relates to our staff. Now, if it's a third party, obviously we are limited in what we can do. But as it relates to somebody who is a staff of the World Bank Group, those disclosures must be made in good faith. Now, that throws in another element to it. So what is made in good faith? The person might believe, because sometimes it's difficult to draw a thick line between what is made in good faith or what is not. So public policy sometimes plays in when we consider allegations of false reporting. So people will come to us and say, look, this person made a disclosure against me, which is not true. And therefore, we want you to investigate the person for making false reports. It's not been easy to do that because the person genuinely believed when they raised those concerns, as a whistleblowing concerns, that they were there, that the situation they were reporting was the case. And then on a deeper look, you find that it's not the case. So this is the issue. But public policy demands that you give them that latitude because you want to encourage and not discourage people from making report, if they have a genuine reason to believe that is a concern.
Okay, thank you. I'm actually going to take one question before we close. It says, thank you, Mr. Bamidele. Your lecture was quite enlightening. Kindly refer to your comment on the additional investigation. You faulted the choice of an internal investigation team, right?
Yes.
My question is, does the work of an internal investigation team prevent further investigation by external investigation, particularly when the outcome is not satisfactory to interested parties?
Okay, there's a lot in that question, but I'm going to try because of the interest of time, right? Now, remember, international development organizations, MDB, multilateral organizations like African Development Bank, like the World Bank, we depend on the generosity of states who give money to us. They are represented on the board. So it's not your typical organization. They are represented on the board. And therefore, you have to be transparent about your ethics program. And so when the African Development Bank issue came up, the anonymous email, which I received, my counterpart in African Development Bank, and they decided to use an internal organ, and I think Alex speaks about it also when he was talking about choice of investigators. You have to not just be independent, you must appear to be independent. And using an internal investigative arm calls into question the independence and therefore integrity of that investigation. This will have been addressed if they had chosen, and all they needed to do was look at what we have done in the past. The World Bank has had investigations of their senior leaders. If you are VP and above and you do something, I don't go and investigate you because, speaking to what Alex said, it's not just fear of your health or death. There's a fear that your career will be destroyed, even as an investigator. And we want to give the appearance of independence, which is key. And therefore, you can understand why the US said, look, we need you guys to do a proper investigation. We don't consider that to be a proper. Some people are saying, it was a power tussle. Yes, but the organization gave the room for that to happen. All they needed to do was look around and see what other organizations do when their senior leaders are accused of wrongdoing. I hope that answers the question.
Yes, and thank you. Certainly for us at CUBU, one of the reasons why clients do come to us, and they come to us a lot, to do these sort of external investigations is because of the issue of independence.
Correct.
In almost all cases, they would already have undertaken an internal investigation, and they want us to, sort of, look at it, see whether the process either outlined in the law or in their code of ethics have been properly followed. If we need to repeat the process all over again, they let us do that because they want to ensure that there is an independence and impartiality of the process so that the result it gives room for less scrutiny, or the ultimate decision gives room for less scrutiny by all the relevant stakeholders. So I agree with you that independence is one of the key reasons why external investigations is very important, especially for misconduct within the workplace. I think that's...
Add anything to that?
Yeah, sure.
Add, or is Adela said it?
I think that's it from us. We've taken almost all of the questions. There have been some questions here about data privacy. We will be having a session as part of our September series tomorrow on data privacy. And we would encourage anyone who's interested in joining that session to please do so. It would also be a session that will run for 2 hours, and we have a very rich panel of experts from various sectors, both from private sector and public sector. So if anyone desires to join that session, they should please go ahead and do so. I think we have the information in relation to joining online. But if you do want us to send you access privately, you can send us an email and we will do so. I would like to thank our speakers, Mr. Bamidele Soya and Mr. Alexander Booth, very well for their time today. This has been very interesting, certainly for me, and I'm sure the audience, because we've had an audience retention of about 95%, which shows that they found this session very engaging. So I want to thank you both for your time, and to say that we will be doing this again. We will be doing this again. So when we call on you in a few months or whenever and ask you, to come and do this for us, I'm sure you wouldn't mind doing so. We have another session next week, also for all regulators on attending this webinar. And the topic is on driving strategies for driving compliance, which will also be facilitated by Mr. Bamidele Soya and one of the senior members of our team, Mr. Olukayode Dada. So we look forward to seeing everyone next week, Tuesday. And for those that are interested in data protection and data privacy, we look forward to having you join us tomorrow at the final session of our September series. That's it from me. I don't know if my colleague has anything else to add whilst we say goodbye, and thank you all for joining.